Welcome to Once Upon a Case. Because the law isn't just for lawyers, it's for everyone. Let's talk about one of the most important legal cases you've probably never heard of. Adams v. Lindsell, decided way back in 1818. It's a case about wool, letters, and a whole lot of confusion, but it basically invented the postal rule for contracts. And trust me, it's way more interesting than it sounds. Picture this. It's the early 1800s in England. There's no email, no texting, just letters, and really slow mail coaches. Lindsell, who's got some wool to sell, writes to Adams offering to sell him a bunch. But here's the catch. Lindsell messes up Adams's address in the letter. So the offer takes longer than usual to reach Adams. And every day, Lindsell's getting more and more impatient, waiting for an answer. Finally, Adams gets the letter, says, "Yes, I want that wool," and puts his acceptance in the mail right away. But thanks to the postal delays, Lindsell doesn't get Adams's reply as quickly as he expected. So Lindsell, assuming Adams isn't interested, sells the wool to someone else. When Adams's acceptance finally arrives, Lindsell's like, "Whoops, I've already sold it." Adams is furious and takes him to court. So what's the big question? When exactly was the contract made? Was it when Adams mailed his acceptance or when Lindsell actually got it? Here's where the court drops the legal bombshell. They say the contract was formed the moment Adams posted his acceptance letter. Not when it arrived, not when Lindsell read it, but the second it hit the post box. That's the famous postal rule, and it's still a thing in contract law today. Why does that matter? Well, imagine making deals by snail mail. If you had to wait until your letter arrived before a contract was binding, nobody would ever know where they stood. The postal rule made things fair. If you've done everything you can to accept, you're protected even if the mail takes its sweet time. But of course, it's not perfect. It only really works when both sides expect to use the post. And yeah, today it sometimes feels outdated. But at the time, it was revolutionary. It made people trust the mail to do business. And it's why some of the rules we use for email and other tech today exist. Who knew a mix-up over wool could change the way we all make deals? That's the magic of legal history. Thank you for watching. If you want more cases explained just like this, hit that subscribe button and I'll see you on the next one.